Hello, and thank you for taking the time today to review this video on Idaho's 4th Judicial District CASA Report training template. My hope is that you'll learn about our report template today, and if you have any questions, you'll reach out to me, Rachel Erickson, CASA trainer, Guardian Ad Litem trainer, and any questions that I may not be able to answer, you can reach out to your advocate coordinator and they could answer for you. So let's get started. If you were familiar with our old template, you may know that we've been using it for a few years now. So you might be asking, why are we updating it all of a sudden? Well, the decision actually came from Idaho Supreme Court. All judicial districts across the state, all CASA programs across the state use the exact same report templates. This is beneficial in case judges are substituting in another jurisdiction. Maybe they're filling in while someone's out on a vacation. They know exactly where the same information is. It also helps if a child were to transfer jurisdictions. That way the new guardian ad litem could pick up and know exactly where to look for that information. One big change that you'll notice right off the bat for these reports is that the report is more child-centered. Previously, when using these report templates, the recommendations and concerns of the guardian ad litem would come at the very end. In this new report template, they are the first thing that the judge will read. It's all of the concerns are front and center, the recommendations are front and center, and the child's expressed wishes is also mentioned right off the bat. These new report templates also align with the judge's bench cards. If you're unfamiliar with the bench cards, these are also used across all judicial districts, and they are what outlines what a judge is and is not able to make a ruling on at that stage of the case. These should be provided to you from your advocate coordinator when they send you the new report template. You can also find them by going to the Idaho Supreme Court's website and searching for the judicial bench cards. So each stage of the child protection case, I apologize for that, has different things, as I mentioned, that the judge can rule on. So depending on where you're at, whether it be the case plan, the 6-month hearing, or the permanency plan, you will be able to check one of these boxes. And I will go into what these mean on the next slide, but you'll have the chance to, it's just a little check that will appear, but it does keep you limited to your main recommendation will be, if we were at the case plan hearing, would be place the child under the protective supervision of Idaho Department of Health and Welfare, vest legal custody and IDHW, or dismiss the case. You'll notice at the 6-month hearing, it's different. It's keep the child under the protective supervision of Idaho Department of Health and Welfare, continue legal custody of IDHW, and dismiss the case. So those two aren't too different, but by the permanency hearing, you should be able to suggest continue efforts at reunification, termination of parental rights, and adoption. So that's when you're moving towards adoption, a guardianship, or if you have a child who's 16 or older, so these could be our youth, another planned permanent living arrangement, or APPLA. So what do some of these things mean? So place the child under protective supervision of Idaho Department of Health and Welfare. This is when the child is on a protective supervision with their parents or legal guardian, meaning that their parents or legal guardian would have full legal custody over the child, but the department is still providing oversight. They're still checking in on the family if maybe they haven't fully completed their case plan and the things that they need to close the case. This could be where this could be beneficial for the family, just because they do still have that oversight. When the children are on protective supervision, as a reminder, for them to be able to come back into foster care fully and for the department to have legal custody over them again, Either the police need to declare the children in imminent danger, or the department needs to go to the judge and request permission to bring the children back into care. So best legal custody in IDHW is what the majority of our cases will be, especially at case plan. This is where the department has legal custody over the children. They are the ones who get to make the decision about visitation, about where the children are placed. This also includes extended home visitation. We know that the judge has to sign the order approving extended home visitation, but while the kids are on extended home visitation, the legal custody of the children still falls under the Department of Health and Welfare. That is why if any other adults were to be living in the home, they would still need to be approved by the department prior to either prior to that individual moving in or prior to the children living there. That way there's just more, it's even more oversight, but it also is just a safety thing for the children. And extended home visits are anything over 48 hours. So keep the child under protective supervision of the Department of Health and Welfare. That's just the children continuing to live with their parents or legal guardians, but maybe they're not quite ready to dismiss the child protection case at this time. And then dismiss the case, that's exactly what it sounds like, vacate and dismiss the child protection case. Another big change you'll see is there is no more legal section. We don't want to forget the legal section completely though, as it could give us some good insight into what the parents might be going through in their lives. So now instead of having it under a legal section header in the historical section, this is going to be under the parents update. So mom's current situation, father's current situation. As always, we're going to continue to look primarily at the last 5 years. If the child is younger than 5, look at the lifetime of the child. With that being said, though, I'm going to jump down to this bottom bullet point. We always want to include all felonies that we can find, even if it's out of that 5-year range. They're just important. Other things that we would always want to include, any protection orders, domestic violence, if it has to do with the parents especially, anything that really shows violence, we want to take some time to highlight. If the parents have any past incarceration, we should include how many days they were incarcerated for. If we know if they're currently incarcerated, let's include their sentencing info, how many days they've already been in, if possible, how long is their sentence, where are they at? Are they in state, out of state? If they are on probation, let's include that as well. Any no contact orders or protection orders should always be included. It's not uncommon for NCOs and protection orders to be with another party on the case. So if mom has a protection order against dad, then we would want to highlight that. If the child has a no contact order with one of the parents, that's definitely important to mention in the parent's current situation. After the case plan hearing, you no longer need to include the legal section in the parent's update, in the parent's current situation section, unless there's a change in status of one of their charges. If a parent were to come in, if the child were to come into care due to a parent engaging in illegal activity, let's say drugs, or they were just arrested for whatever the incident might have been, then that's probably going to be an ongoing case, and we'll want to keep track of that. So we'll want to update the judge if we know there's an upcoming hearing, if maybe there's been a plea deal reached, include that information if you're able to obtain it. And instead of including all the information, we've kind of pared it down a little bit. If the individual has a long I-court history, then, and maybe they have a lot of driving infractions, we don't typically highlight those. So what we're going to change it to is just like a little narrative. According to I-court, Miss White has at least 10 prior cases. 4 of these are juvenile cases, with several being drug related, but her adult criminal history shows, and then you can list out the things that we talked about before. You know, maybe it's an endangerment to child, drug related, violence in the home. Those are things you'd want to list out. Then if they are incarcerated, you could kind of highlight that, but also mention, you know, although we didn't list them out, there's been multiple misdemeanor charges as well. If something shows a pattern, go ahead and mention that. And if you have questions on this, please reach out to your advocate coordinator, and we're more than happy to take the time to explain how this should look. The last big change that I'm going to show you on the reports is now there's a new section labeled Other Cases the Children Are Involved in. So this would be any child protection case that the children are actively a part of in other states. This could happen if the families originally started in Oregon, let's say, and then moved to Idaho. That does happen every so often where we get cases that have crossed state lines. So we would just want to point that out to the judge. If you are working with youth, they are sometimes involved in their own juvenile cases as well. We would want to point that out. If the children have been involved in a custody case between their parents, list that. And then any guardianship cases as well. So if this is a grandma currently trying to get guardianship over the child, we would highlight that. And then last thing to note is the format that we're going to ask you to submit your reports in: size 12 font, Times New Roman, 1.5 spacing, and 1-inch margin where you're not doing bullet points. Your advocate coordinator is more than happy to help correct this each time, but we like to point it out since we know not all computers are defaulted to Times New Roman or size 12 font. Now that we've gone over some of the changes that you'll be seeing in the new templates, I wanted to take some time to show you what they'll look like. So as you can see off the bat, there's no more boxes that you have to try to duplicate that list the child's name, date of birth, if they're in relative placement or not. That's gone. There is a section for the referrals. And then, as I mentioned, this is the section that Matt aligns with the bench cards. So you could check place under the protective supervision of Idaho Department of Health and Welfare if you thought that was appropriate. Under that, you have space to put your own recommendations. Maybe the child needs speech therapy, or you really think it would benefit the family to go to family counseling. This is where you would put that information. The expressed wishes, we always encourage you to have this information if possible. I know it says here not required, but even if a child isn't old enough to express their own wish, you're more than welcome to kind of talk about the things they love. Say, although Bobby is not able to express his wishes at this time, he loves riding bikes, he loves Paw Patrol, and chocolate is his favorite food group. You could also put something along the lines of, at this time, this guardian ad litem does not know the child's expressed wish, as they were focusing on building rapport with the child. That's always acceptable at the beginning of a case, because some kids just take a little bit longer to open up to adults. As we scroll down, You'll see guardian ad litem concerns. Remember, we talked about how all of the child-centered stuff is at the very top now. So this is where your concerns would go in. And as before, if there's concerns or recommendations that you're making, they should be brought up in the child's well-being section. So let's talk about that a little bit more. If I'm suggesting that the child needs extra tutoring, if I'm recommending that the child needs tutoring for math, where does that come from? Make sure to mention that in the education for each child section. So child contacted, this is going to be keeping track of how often you've contacted the child or you've observed the child. Visitation is visitation between the child and their family members. This could be parents, siblings, grandparents, aunts, uncles, cousins, whoever it may be. It does not include visitation between the child and the guardian ad litem. This should be focused on the child. Education for each child. Pretty self-explanatory. Please mention whether or not the child is in the same placement as they were prior to this report. If they've been missing a lot of school, that's important to note. If the teachers report to you that they're really struggling in a section or really excelling in a certain section, please mention that as well. We have medical for each child. As it points out here, this would include medical, dental, vision, mental health history, and any diagnosis and treatment that the child may receive. And that follows after that is current services for each child. Now, this could be something a little special that maybe a child wouldn't receive. This could be speech therapy. This could be OT, PT, infant and toddler program, just things that children don't necessarily receive every day. Under current placement for each child, you are going to want to update how many times the child has been moved. Have they been moved since their last placement? And are they placed with their siblings? That's always important. Also looking at, is the place that they're living in safe for them? Do they have their needs being met? Is it a healthy environment for them? And do you continue to recommend the child living there? And then, as I mentioned before, legal cases involving a child. So this would be custody cases, juvenile cases, any other child protection case that the child might be a part of. And then we run into mother and father's situation, the parent situation. Please remember that you can have more than one mother, you can have more than one father. So add on to this to reflect whatever your family looks like. This is also where you would put the legal history now. So if I were talking about the mother, I would talk about Miss White. She's currently incarcerated. She's not sure what will happen, but she misses her kids. And then I would include Miss White's legal history below that. And then last but not least, we still need to include the persons contacted, foster parents, social workers, children, teachers, parents. Please, as a reminder, never include the foster parent's last name. We only refer to foster parents by their first names. And then documents reviewed. So this is the report for adjudicatory hearings and for case plans. And next, I'm going to show you the report template we use for 6-month hearings. So here's the template that will be used for 6-month review hearings. The biggest change you'll see here is that the recommendations have changed ever so slightly. Instead of it saying best legal custody in IDHW, it says continue legal custody, and then keep the child under protective supervision, and then dismiss the case remains the same. As we scroll down, it does say the GAL offers the following information since the last written report. Please remember that each report should always have new information. You should always be actively meeting with the child at a minimum of once a month and updating this information as you go. Your concerns and recommendations may also change as the case progresses. The rest of the report template, I apologize, follows the same layout as before. So children are contacted, visitation, education for each child, medical for each child, current services for each child, and then it includes the current placement for each child. If you have more than one child on your case, I would encourage you to say Bobby, and then talk about Bobby's current situation in education, and then Sue's current situation for education. Then when you get to medical, do the same pattern again. So if you started with Bobby up in education, start with Bobby under medical, and then follow with Sue. If you want to do it oldest to youngest child, that's perfectly fine. Youngest to oldest, that's fine as well. However you decide to list the children is perfectly fine, but I would encourage you to continue keeping the same order. As I mentioned before, under the parent situation, unless there's a change in legal status, whether there be an update to the case, if there was charges against the parents when the children came into care, or maybe there are new charges, maybe the parents were arrested or charges were brought forth for another reason, you do not need to include the legal history under mother and father after that. If there is updated information, please include that, but besides that, you do not need to. Persons contacted should update as well, and then documents reviewed since last written report would also update. And the last report template I'm going to show you today is the permanency report. So at this point, the children have most likely been in care for about a year. So the recommendations that reflect the bench guards do change. At this point, you should be able to say continue efforts at reunification, meaning we are still we think the parents are working hard, but maybe they're not quite there yet for the case to completely vacate. So let's keep giving them that support. Let's keep working at it. And we want to try to reunify the children. The next is termination of parental right and adoption. So at this point, we would move to a TPR hearing if that's the way the judge decided to rule. And after the TPR hearing, we would move towards adoption and then guardianship. If you have a youth child, 16 and older, another planned permanent living arrangement, APPLA, is where they would start getting the child ready to prepare them for living on their own if they are not reunified with their family. Knowing they don't have much more time left in foster care, since children age out at the age of 18, this would fall on the department to help put that plan together. And as I scroll down, you'll notice that the information does not change. We still have recommendations, expressed wishes, your concerns, and then the child's well-being, child contacted, visitation, education for each child, medical for each child, current services, current placement, legal cases involving child. And once again, this should all be updated since the last hearing. Mother and father's current situation, depending on what your family structure looks like, please feel free to add extra mothers, extra fathers. and then the people you have contacted and the documents you have reviewed since your last report. If you have any questions at this point, please feel free to reach out to your advocate coordinator, and we're more than happy to help you work through those. They may be case specific, which is why I was not able to answer them today. But please jot down any questions you have, shoot them to us in an email, and we're hoping to put together a questions and answer document. So you may be able to review that as that is built as well. But we look forward to hearing from you. And I hope you have a wonderful day. Thanks. Bye-bye.